All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
Well, Phil, you teed that up great for us. We've got two recent developments, big developments, particularly in the agency side of the government. The first one is the one that you've mentioned right from the get-go, and that's the non-compete issue. This week, the Federal Trade Commission finally announced its final rule, not just a proposed rule, but final rule, having voted on it 3-2 by the commissioners to essentially ban non-competes. And yes, you heard that correctly. That's what they're doing. So they are taking the steps now to put that rule into effect. It will go. The rule is essentially saying that your non-compete agreements are going to be invalid. And this isn't just moving forward, but it will also be retroactive under this new rule. So meaning any agreement that you have currently that has a non-competition portion of it, that's going to be invalid. Now, it's a good time to kind of mention what's the difference between a non-compete and a non-solicit.
I think that's a good idea. Yeah.
Because these
two different agreements. Yeah.
Two different agreements. So let's start with the sort of more limited one. Non-solicit is that you cannot go and, recruit clients. If you're a salesperson, you can't go take your book of clients that you developed with your current employer and go to another employer or even start your own company and solicit or contact those clients for their business. Whereas a non-compete says you can't even work in that area doing that very particular job for any other employer. So for instance,
compete against, I kind of always tried to think of it as I can't compete against my current employer in their marketplace. And the challenge to that is when you work for a national employer, right? Or you work for a local employer, but you want to stay local and all you've done is worked in that industry.
That's right. Yeah. And that's the kind of catch of the non-compete, right? That's why it's so powerful. Say you're in a business where you're selling cranes or something, and you're one of two people in town. If you want to leave that place to go to the other person, you can't under that non-compete. You're looking to move. You're having to leave the region. And if you're national, like you said, Phil, that's really handcuffing. So this issue.
I even think about like a simple car dealer, right? A car sales might have a non-compete today that prevents them from, going to the car lot across the road. They're often clustered together in a community. And now this would give them the flexibility to do that.
Yeah, and that's right. And so this is kind of a little bit of a recent trend across the state. So typically states have been allowed to enforce their non-competes, whether they want to or not, kind of make their own rules. So for instance, us here in Missouri, non-competes are totally okay. And in fact, people use them all the time. Whereas if you go across the river to Illinois, they're much more limited. You can't have non-competes for certain people who are making a certain amount of money. It's targeted toward eliminating non-competes for lower income workers. Now, if you go other places like California or Minnesota or Oklahoma, or even sort of moving into Washington, these are just sort of blanket bans on non-competes. And we're seeing the federal government sort of step into those roles, which is why I think you're going to find there's going to be a legal issue here that's going to have to be resolved by the courts. And that's going to be a constitutional issue. One, does the FTC have the authority to do this? And two, if it's already been been delegated to the states, are they infringing on those state rights? So, what I could tell your listeners here is that it's going to take 120 days for this to go into effect. No need to rush into revising anything at the moment. But, keep it in the back of your mind that you might have to sort of revise your agreements with your employers or your employees, and you might even have to scrap some of the ones that you already have. So keep your fingers on the pulse of this one. We do expect there to be a significant legal challenge because, as you'd imagine, employers have a very, very high interest in this. I mean, we're not protecting just the assets of the company, but also things like trade secrets get involved here, disclosures, what people can share. The idea the Federal Trade Commission is doing here is trying to open up competition by doing this. But in fact, it's very much restricting what companies can do. So that's something to keep an eye on.
So Tom, understanding Ogletree's firm position is know what you have in place, right? Let's be aware of what we have in place. Let's know who has the non-competes. Let's make sure we're separating out non-competes from non-solicit to some of these other things that exist. That sometimes get bundled into one statement. Non-compete, non-solicit, it's one agreement. So let's know what we have in place. Then let's see what the law challenge is before we go out and make any changes, and what happens with that, to see if there's a delay in the implementation because something's going to change. Is that maybe the school of thought?
That's right. And sort of practically speaking, Phil, I mean, if you've got a contract that's, provision of it or even the whole agreement is void, it's like you're working without the contract anyway. So there's no real reason to rush into recreating something if you're just
Right.
if essentially got a useless piece of paper.
Right. Would the non-compete, if they are combined in one, which I do see a lot of employers submit them as one, and they don't always separate them into two agreements. If my non-compete is void, but I still have my non-solicit language within that, I think that's where it gets a little bit tricky to make sure it's not so mundane. The language isn't so gray that one voids the other.
That's
That
right.
would be something we want to look for.
Yeah, that's right. And to look for something called a severability provision in those contracts. And what a severability provision does, it says if one portion of this contract is void or declared void, it doesn't invalidate the other portions that are not.
Very good. Yep.
Yeah, so you might see that, and it's oftentimes put in there. It's usually, I'll tell you, it's usually towards the end of the agreement. So you might want to look there if you're looking for it, but check for those. But really, the FTC is taking a real broad approach here, painting with a broad brushstroke. So,
Great.
I wouldn't be surprised if those non-solicits come under fire too.
All right, great. What else you got for us, Chibs?
So the other big one is the the sort of OT or overtime regulations and rules changed recently, and that change is going to go into effect pretty soon for many people. So it's going to be a two-tiered change, but really what we're doing is we're changing the sort of classification standard for exempt and non-exempt workers. So as you might know, your exempt workers may not be subject to overtime, but that's based on, how much they earn. So that is getting raised. So for instance, it's going to be two-tiered. One part is going to go into effect in July of this year, and then the second sort of wave is going to go into effect January of next year. And what we're doing is we're increasing sort of the minimum qualifying salary for what we've considered traditionally, white collar or not our, exempt workers, and that's going up basically from about $700 a week to now about $1,200 a week, or almost about $1,200 a week. So it's almost going up about 50%. So it's a lot, and the big sort of takeaway here is that the threshold, when you're talking about an annualized salary, used to be essentially about a little under $60,000 for your exempt folks who are basically for that non-exempt, not exempt classification. Now it's it's gone up a little bit. I'm sorry, it's gone up to 60. It used to be about 40 or about 35. So it's gone up, and now it's going to go up even more. And it's going to go up in July. The weekly threshold is going to be about $844 a week, or about, if you're annualizing that, about $43,000 a year. And then in January of next year, it's going to go up to essentially $58,000, almost $60,000 per year annualized salary. And what this means, and this is the big issue, is that it's going to require many employers to go back and audit who they're classifying as exempt and non-exempt. Because as we know, if somebody's non-exempt and they should be getting overtime and they're not, that's a problem.
Yeah, we've seen the case law on that give out high dollar rewards.
Yeah, exactly. Yeah. And I will say that, this is sort of a retread. Many years ago, under the Obama administration, there was an attempt to do this very kind of similar concept, and the court struck it down. So there's a likelihood that happens again, but we'll have to see how that legal process plays out. But this isn't a new thing by any means. It's just sort of round two. It's been a while. It's been a while since we've seen it happen. So, but like you guys, it's as the whims of Washington swing, so do the agencies.
Yeah, no, that's true. And I mean, we get stuck in the middle on that. I have a sense that while this one might get some challenge, I think the day's coming that we're going to see the change here. That I feel like these are going to be a little bit more sticky than it was the first time around, just due to the way the agencies and things are moving right now, where I can see the non-competes getting delayed.
Yeah. I agree with you, Phil. And you don't have to look too far to sort of see practical examples. It's just a lot more expensive to live these days, and you see prices going up. And I think the government is sort of taking that into consideration and trying to say we need to get wages up to speed to compensate for inflation and for other various sort of cost of living, which is why I agree with you. I think this one's got a lot more ability to stick than perhaps the FTC one.
And I know our members and the employers that, I deal with all the time, we said, we need to slow this wage inflation down. I mean, it's one of the top concerns of executives is wage inflation and being able to continuously, pay an increased wage and manage, the overall inflational factors of their business. So, we're stuck in this whirlwind of change that's really expensive change for us on all fronts.
That's right.
All right.
Yeah.
Tom, that's great. Great insight. Anything else from Lawyer on the Clock?
No, I don't know if I have enough time.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link, aimea.org/This Week at Work, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.